All right, well, good morning, everyone. Thomas Montgomery. It is a beautiful Monday morning, July 8th, 2024. Of course, we have a hurricane that's hitting the Texas coast and working its way across the state today. So we'll see how the weather affects us later today. But as of now, all is calm. And we are here today to talk about understanding liquidation. So let's put it in perspective before we get into the details. What you and I do, our primary focus is to build financial literacy in the small business owner environment. Most entrepreneurs don't know what you and I know. What you and I know is that there is a formula for funding, that anyone can get at least $100,000 to start or grow a business if they meet the fundability standards to qualify. Doesn't matter how badly you want money or how badly you need money, we need to qualify. And so with that, there's the 3 C's: credit, collateral, and capacity. And that's kind of surrounded with the fact that we need to have a loan package, the business plan, and financial projections. The great news is that's what we do. So you as an affiliate, all you do is drive people to your landing page. We get them initial funding offers. They pick the offers that they want, puts money in their pocket, and then we work with them over the next 30 to 60 days to create a fundable business. So that's the big picture. But I think you all are familiar enough with that. That's really not what we're talking about today. Today, we're going to drill in. We're going to drill in to the liquidation process. And I want to make sure you all really understand this. Not that we're expecting you to go out and educate clients or prospective clients on it. I'd actually recommend not, but I want you to understand it well enough for your own use. So 3 C's we talked about: credit, we're talking about business credit, collateral, and capacity. On collateral, it's important that our clients have collateral to pledge for the loan, because most lenders want collateral. So that protects the lender in case the borrower doesn't repay. Well, the problem is a lot of our clients don't have collateral or not enough collateral. So part of what we do, and we mentioned that the promotion that we're running is we're going to transfer $10,000 over to all clients. And so I want to explain to you what that is and how that works specifically. So why would we transfer 10,000 of QuickCash over to clients that enroll through your landing page? So they have collateral, and then we turn around and liquidate that collateral so they have capacity, so they have cash. So it actually helps them with 2 of the 3 C's. So let's go through the what and then the how. So as I just mentioned, by us transferring 10,000 to each client that you sign up, we're able to take the $10,000 and post that on their balance sheet. So a balance sheet is a financial statement that every small business owner should have. We will help them create one if they don't have one. And the balance sheet reflects assets and liabilities of the business, not of the business owner, but of the business. So assets are things that the business owns, and then liabilities are the obligations that what the business owes. So we need to have a strong balance sheet to get approved for funding. And again, most clients come to us with a weak balance sheet. They have what is considered a collateral shortfall. So how do we address that? We transfer receivables. And so we're going to go through and let you really see how the mechanics of that work, and we'll actually go through some of the specific documents. So first thing that we're going to do is get those assets on the client's balance sheet so they qualify for the loan, and then we're going to turn around and help them liquidate. So any business that has receivables would rather have cash. So there's the process that's called the liquidation, moving it from a debt owed to the business to money received by the business. Any questions so far, or are we all okay so far? Okay. So let's go through the liquidation process. So let's pick someone. We have Bill on the line, and Bill and I were talking this morning. So let's say that Bill has a balance sheet, and Bill's balance sheet it's light. He has inadequate collateral for the amount of loan that he wants. So we transfer over at no cost to Bill $10,000 of receivables. So let's actually look at what that would look like. So here is an example of a contract that creates a receivable. So this is our cheap at business address contract. It's a real executed contract between a business called West East Coast and with us. So West East Coast is a tenant. They promise to pay rents for the office lease. And this is the full lease agreement. So it's a fully executed, legally enforceable lease agreement. So we scroll on down and on down. We'll see what's important about this is that the lease agreement includes a personal guarantee. So here it was signed by Mr. Williams. And we'll scroll down a bit, and there's a personal guarantor. So Robert Williams is the guarantor for West East Coast Capital's lease. So you might say, well, how does this affect Bill, right? Bill, who's a real person, Bill has a light balance sheet. How does this help Bill? Well, what we would do is transfer ownership, a title transfer. So now Robert Williams Jr. and West East Coast Capital no longer owes us. They don't owe us anymore. Now they owe Bill. So now this is a receivable that's been transferred to Bill. And there's no question that Robert Williams signed it, right? We have a unique document number. We have the IP address that Robert used. Again, we have his electronic signature, the timestamp. So this is a bulletproof contract that Robert Williams owes on that now Bill owns. So if Bill owns this receivable that's worth around $11,000, $12,000, now Bill can legally, ethically, morally put it on his balance sheet, and we'll help him do that. So the receivable starts with a true agreement, a true debt, real, that's owed and transferred to, we'll say, the client, in this case, Bill. So we transfer this to Bill. Well, once we've transferred it to Bill, and we can go back to our agenda, now Bill can go ahead and put it on his balance sheet. Bill can do that instantly because it's now really his. Well, could Bill have just listed it, wink, wink, as his if it really wasn't his? No, that's considered bank fraud. Because if you fabricate financials with the intent of using it to borrow money, that's bank fraud. So it's only after we've legally transferred ownership of the debt to Bill can he use it on his balance sheet. Now, the first thing we want to help Bill do is, in the liquidation process, which is what we're talking about here, we want to help him factor it. So factoring may not be the right choice for everyone, but for many of our clients, it is. So here, Robert Williams and West East Coast Capital owes Bill, the client, we'll just round off and say $10,000. It's actually a little more than that, but we'll just say $10,000 to keep it simple. Well, Bill would really like to have access to the money right away instead of just the paper, the receivable. So we can help Bill factor this. Now, this again isn't right for everyone, but for most people it is. The factoring company charges a 3% fee. So if we help Bill factor this, and again, we're going to round it off and say it's 10,000, it's actually a little bit more. Would Bill get 10,000? No. Bill would only get 97% of it. So Bill would get 9,700 normally within 1 to 2 business days. So we've transferred the receivable, what we call the QuickCash, over to Bill day 1, and then we can help Bill factor it, and Bill should have the factoring distribution on day 3 normally. So now Bill's sitting on 9,700. Can he still claim this as an asset on its balance sheet? Yes, because when we factor, we're not transferring ownership to the factoring company. The factoring company is using the receivable as collateral and advancing that money to Bill. So great. So Bill's got $9,700 on day 3 using that theoretical timeline that he didn't have before. So Bill's happy. Plus, he's got that big boy balance sheet. So Bill's really happy. Now, does it end there? No. We want to liquidate. We want to liquidate the receivable. So the first thing that we're going to do is then invoice, and we can do these things if the client, in this case Bill, if the client wants us to handle the liquidation process, we can do so. If they don't want us to do it, we don't have to, but we're licensed and bonded, so normally Bill or the clients in general would want us to do it instead of themselves, because if they're not licensed and bonded, they shouldn't be doing it. So once Bill has the 9,700 in his pocket, let's say on day 3 of this sequence, then we can go ahead and invoice the debtor on Bill's behalf. So I don't have an example of that, but it's an invoice. So the invoice goes to West East Coast Capital as well as the guarantor. Remember, we had a guarantor down here. No, it was here. Sorry, the guarantor. So we're going to invoice and say, hey, you owe. And it may very well be that Robert W. Williams and West East Coast Capital says, oh, you're right, I owe, and they pay. Ideally, that's the way it works. Doesn't always work that way, but ideally, that's the plan, because it's truly and clearly a legal and enforceable agreement. There's no question that Robert Williams owes, rounded off, the 10,000. Let's go back to our agenda. Well, what happens if that is not enough? What if this guy, and he goes by Whit, he didn't actually go by Robert, he goes by Whit, but what if Whit doesn't pay? Well, what are we going to do then? Then we're going to send a demand letter to the debtor, and we have an example of that. So Robert Williams, West East Coast Capital, we're going to send a demand notice and notice of breach. And again, we know when the contract was signed on or around 5/17, so hopefully that matches. Let's go over and see. Yep, May 17th matches. We know his social, we know his driver's license, we know his date of birth, know all that. And then of course we can validate the agreement because we have the IP address that it was signed on, which I showed you a moment ago, the IP address here. And then we have the unique document reference number. So this is a bulletproof breach of contract case, right? There's absolutely no question that Robert Williams is the guarantor on this contract that has been defaulted, that's now owned by Bill, and the money should be paid. So what we're going to try to do first off is to get the debtor to pay. Sometimes that works, a lot of times it does, but sometimes it doesn't. But let's go back to the process then. What happens if Robert doesn't pay? Well, then our attorneys and or paralegals are going to draft a lawsuit. So we haven't filed yet, because the goal isn't to go to court. The goal is to motivate the debtor to pay so Bill gets his money, the client gets their money. So here's an example, a real example of the lawsuit that was drafted actually just, I think, this morning. So here we're going to be the plaintiff. So we're keeping Bill or the client in general out of the court system because they don't want to mess with it. And a lot of times when you're trying to collect money or sue people for money, they get ugly and they say ugly things to you and make threats and all that. So we keep the client out of it. So we'll serve as the plaintiff, and then the defendant is the person that owes the money, right? And so this matches to this underlying agreement over here. So let's go through the way that the petition. So the petition is what's drawn up to be submitted to the court to file the lawsuit. So the petition is filed, and then once the court processes it, after the fees are paid, then they issue a citation, and then the person is served either at home or work or however. But let's go through the construct of the agreement. So again, we're the plaintiff. We're taking care of this on behalf of the client, and the defendant is both the company and the guarantor. So we talk a little bit about discovery. If you have more questions and want me to go deeper in any of this, we can, but we'll just go through it at a high level. Just use the Q&A if you have questions or comments or concerns. We clarify who the plaintiff is. We're handling this for Bill in this theoretical case, so we're the plaintiff, and then the defendant. And so we know where to serve the defendant at their business address. We know their driver's license number. We had the full information over here, but when we file the petition with the court, normally we're only providing the last 3 digits of the driver's license and social security number. In all of the agreements that we litigate, the venue and jurisdiction have been specifically stated as Wood County, Texas. So we can go back and validate that. Let's go back to the agreement that was defaulted by Mr. Williams, and we can go match what I just said with the agreement. So we always want to be ethical and accurate. So we'll go find where venue is stated in the original agreement here eventually. I think if you have any questions or comments or concerns, you can type it into the Q&A, but I'll find where that is. I should have looked it up beforehand. We're getting close. Yeah, so controlling law. So it's going to be Texas laws, and then somewhere it's going to say that it's going to be where the property is located, which is Wood County. Now, also what's important about the agreement is that the debtor, in this case, Mr. Williams, agrees to pay all the cost, charges, and expenses with collecting the money. So instead of the client, in this case, Bill, absorbing the cost for collecting this money that wasn't paid by the debtor actually is responsible for the collection cost as well. So we have the venue, the jurisdiction, we clarify the facts. Now, this is not just a normal lawsuit. There's different ways to file lawsuits. This is a unique way of presenting the case where often it'll never even need to go to court, because let's scroll down, that it is called a suit on sworn account. So that's a special type of a lawsuit that allows for accelerated processing within the courts. Typically, it never even needs to go to trial because it's so clear that the debtor owes it. Because if the debtor hadn't paid Bill already, Bill's like, man, I don't want to wait forever to collect the money. Let's move this along. The way that we have structured this is that it allows for an accelerated resolution. So we have to state the breach, the contract, that we have all the documentation, unjust enrichment by the debtor, and it allows us to expedite it. So with that being said, then we'll sign this and file with the court. But in most cases, we never get to that point, because there's no question that the debtor owes, in this case, Bill. So we want to factor it right away. As long as that goes through, then that's money in the debtor's, or I'm sorry, in the client's pocket within a couple of days. And then typically long before we have to go to court, we're able to collect. But I wanted you to understand the steps. So first we invoice the debtor, then the demand letter, then the lawsuit is drawn up with a final offer to resolve, and then if the debtor still doesn't pay, then we'll file the lawsuit. All right, so Dean asked, why does Robert owe Bill? Okay, so Bill was assigned, so let's go back. That's a great question. So there's a whole industry, Dean, and others, called debt buying and debt selling. Encore Capital is one of the largest debt buyers and debt sellers in the nation. They're a publicly traded company based out of California, I believe, a multi-billion-dollar industry. So what we're doing is Bill didn't have enough collateral for his loan. So we're transferring collateral to Bill. We've transferred through a bill of sale this contract to Bill. So now instead of Robert owing us, Robert owes Bill. Thus, Bill can put it on his balance sheet. We said, Dean, that companies need to have assets on their balance sheet for collateral. And I'm showing you the specific steps that we go through to legally and ethically provide collateral for the clients to use on their balance sheet so they can qualify for funding. And then also I'm giving you kind of an inside look of how we go about liquidating that. Does that make sense, Dean? So again, as an affiliate, you don't really need to know how the sausage is made, but I think it is good to know that we help clients have fundable businesses. We know that we have to follow the financial rules of the 3 C's: credit, meaning business credit, collateral, and capacity. And I'm showing you, including the source documents, of how we add collateral to clients' balance sheets so they qualify for funding. Okay, Michael asked, is the 10,000 QuickCash? So we announced, I think it was on July 2nd, we announced that we were doing a promotion for the month of July, that all clients that our affiliates bring through their landing page between and including July 2nd and July 31st will receive this free promotion. So it's an extra bonus for the client at no extra cost to them. So we're not selling them this, we're giving them this as an extra incentive. And let me know if that answers your question, Michael, if you have a question on that. Now, Michael's question is good. So I think what he's getting into for the liquidation, when we liquidate the receivables for clients. So again, let's go back to Bill. If Bill wants us to liquidate this for him, we can. If he doesn't want us to liquidate it, it's okay. It can still sit on his balance sheet. But if Bill wants us to liquidate it, do we liquidate it for free? No, we don't liquidate it for free. We do a 50-50 split. And you might say, oh gosh, that's horrible. So now instead of Bill getting 10,000, he's getting 5,000. That is not correct. Why? Because remember, I showed you that the debtor has agreed to pay for all the collection costs. Let's go back to where that was referenced. Right here in section 41. So Robert is responsible for our cost of collecting this money on Bill's behalf. Therefore, when we file the lawsuit's not for 10,000, but it is for 20. Oops. I didn't mean to cross it out. There we go. 20,000. So essentially, the pie has doubled. The amount that the debtor owes has gone from 10 to 20, And then we're splitting that 50-50. So what does Bill end up with? Half of 20, which is 10, which is what he expected to begin with from the defaulted contract and from the agreement. So that's what makes it very valuable, is since the debtors are responsible for the collection, the court cost, the litigation fees, instead of it coming out of Bill's pocket, it's coming out of the debtor's pocket. So the debtor would be smart to settle this without going to court, right? Because we're going to win it. How would we lose this contract? Any of you that have a legal background, can any of you tell me, oh, let's go back to this. Can any of you tell me how possibly Robert could win a lawsuit for defaulting a lease? He can't. There's no out. There's no question that he signed it. He's responsible for it. There's no legal defense, as they call it, where Robert could say, I don't owe it, because no, he owes it. Therefore, Robert's kind of a fool to let this go to court, because Robert's either going to have to come to court in Wood County, Texas, over here. He's either going to have to come to court in Wood County, Texas, or hire an attorney to go to court for him in Wood County, Texas, for a lawsuit which he's absolutely going to lose. Makes no sense. Therefore, most debtors won't go to court. They'll settle before we get to that point, because there's no benefit. Once they see that this is progressing and it's not going to go away, most people will settle rather than go into court. Very few cases go to trial. Only about 10 to 15% of breach of contract cases go to trial. In most cases, when they go to trial, we'll just get a summary judgment, because it's a waste of the court's time. It's a clear-cut breach. The debtor owes it. All right. Michael's asking about the promotion ending. So we're running this promotion from July 2nd to July 31st. So any client that you enroll as an affiliate through your landing page between the 2nd and 31st of July will get this promotion. I don't know if they'll continue it afterwards or not, but it sure is another arrow in your quiver that should allow you to enroll more clients, because in addition to them enrolling with no upfront cost, in addition to them getting a funding proposal for offers that they qualify for now, in addition for us working with them to get them from where they're at to where they need to be to get at least 100,000 guaranteed, in addition to all of that, which is great to start with, now we're going to transfer 10,000 QuickCash to them right away. And so that should help you close pretty much all of your prospects, right? Because we're not salespeople, we're problem solvers. So if you can find someone that has a problem, meaning they need money to start or grow a business, you should have a remarkably high enrollment percentage, especially with this extra arrow. All right, so Purvis is asking, yeah, so there's different types of agreements that we can transfer to clients for the QuickCash. So this is an example, when not the only type. So I didn't mean to suggest that. But in general, in the industry of debt buying and debt selling, normally it's defaulted mortgages, defaulted car loans, defaulted credit cards, defaulted professional service agreements. Those are the main categories that are bought and sold and litigated, collected off of in the marketplace. This is just one example, not the only type of purpose, so I apologize. But this is an accurate one. I wanted to show you through the process. Michael's right. Yeah. So in the startup program, which isn't something that our affiliates offer, in the startup program, clients do receive the 10,000 as well. So that's right. So we have different programs, some programs that our affiliates don't offer that our branch offices do, and the 10,000 allocation is part of the startup program. That's correct, Michael. It's normally not part of the free funding proposal campaign, but we decided, hey, let's give that a try for the month of July and see if that's an extra arrow in your quiver that would help you close more deals. And so far, it's been remarkably well received because, again, this process, especially the ability to factor right away, gets a lot of people's attention. But again, remember on factoring, there's a couple things here. So we're going through a bank. The bank is not buying the debt from the client. They're factoring. They're essentially loaning 97 cents on the dollar. So let's say that someone wanted 100,000 of QuickCash, and that's actually what Bill's considering. So let's say Bill had 100,000. Theoretically, then we could factor that for 97,000 in his pocket. But again, that's an advancement on those receivables. The bank didn't buy the receivables from Bill. They advanced. So we still need to collect the money afterwards. But this would allow for the most immediate transfer of funds. But it's a bank. There's an application that has to be completed, but it's much more about the receivable than it is about traditional underwriting. So I don't think we'll have a problem in most cases. All right, so hopefully I didn't confuse you. Hopefully you have a better understanding of the liquidation. We've looked at source documents, we've looked at demand letters, we've looked at the actual petition that will be drawn up and shared with the debtor, and then if the debtor doesn't respond, doesn't make some sort of settlement offer, some sort of payment arrangement, then we'll file that with the courts. And then once it's filed, then they'll be served. Once they're served, we'll get into the discovery phase. And the discovery phase, which is referenced a little bit here, is quite exhausting. So a lot of people, if they haven't paid up to this point, normally will settle because the discovery phase is very time consuming for them. If they're hiring an attorney, then they're spending a lot of money on attorney cost of what, $200, $300, $400 an hour. If they don't have an attorney, they're chewing up a lot of their own time. And if they don't comply, then we can file for a contempt of court motion, and then they could actually be arrested. So you can't be arrested in the United States for not paying a debt normally, but you can be arrested for contempt of court. And so one of the very powerful strategies is getting people to either commit perjury, to lie to the court, or to not comply with the court, which can typically result in them being arrested for 72 hours. We've had people call us as they're getting arrested in the back of the squad car if the officer allows them to keep their phone, trying to settle rather than going to court. So again, we take care of the dirty work. That's not the debtor's responsibility. All right. Well, I think we covered a lot. If there's questions, comments, concerns you have individually, we certainly can get together. You know our phone numbers, you know our emails. We'll be back tomorrow morning. Have a great day, and I hope this was useful. Thank you all. Bye-bye.